And I will call the zoning board of appeals meeting to order. Emma Lilly, would you please go on mute? Never mind, I muted you. I have with me in the room from the zoning board of appeals, John Benares, Georgia Pendergast, Colleen Moore, and myself, Sarah Melish. We have only 4 people here tonight. Also in the room is Brian Solacey, the liaison from the select board. We will be opening with the continued public hearing for 2 Blossom Lane. I move to open the continued public hearing for the application of Benjamin B. Timon, attorney, on behalf of Samuel and Tracy Byrne of 1 to 3 Blossom Lane for the appeal of an administrative decision under section 7.4.5 of the zoning bylaw dated November 13th, 2025, regarding a request for zoning enforcement filed with the building inspector on October 30th, 2025. For action against structures, conditions, and uses which are not in compliance with the zoning bylaws or special permit granted by the ZBA on September 5th, 2019 at 2019. At 2 Blossom Lane, Assessor's Map number 17, lot number 12, in District E, filed with the town clerk on December 15th, 2025. Do I have a second to open the public hearing?
Second.
Georgia seconds. Roll call vote. John?
Approved.
Georgia?
Yep.
Colleen?
Yes.
And Sarah votes yes. We did receive a letter from Miss Julia Berry on behalf of Rodney and Carla Smith, property owners of 2 Blossom Lane, responding to the issues raised in the appeal. Did all members of the board receive that?
Yeah.
Yes.
Okay. What I'm going to do is I'm going to ask Mr. Timon to provide some opening comments regarding, including a brief history of the background since the special permit was granted in 2019. I will then offer Ms. Berry an opportunity to provide opening comments with respect to the property history. We'll then discuss each of the 4 issues separately so we don't get confused and go through them one by one and give both Mr. Timon and Ms. Berry an opportunity to speak separately on each issue raised. We'll also be taking public comments. Okay. Go ahead, Mr. Timon.
Thank you, Madam Chair. Benjamin Timon, with me is my colleague, attorney Studi Venkat, who will also be participating in the presentation on some of the 4 issues. It's nice to see at least 2 of you who I think we got to spend some time together 3 years ago on this project, and I think Mr. Solacey as well been on the board at that time. So I appreciate the opportunity to provide sort of some procedural context, and I'll try to keep it as succinct as I can. A special permit was granted for the redevelopment project at 2 Blossom Lane in 2019 by this board. It was a special permit under Chapter 48, Section 6, which is with respect to extensions of prior non-conforming structural structures or uses. So like many properties, it was an undersized, many properties in Manchester, undersized lot with grandfathered prior non-conforming structures, but the expansion of that project required a special permit. And I know the ZBA is quite familiar with that standard, which is whether or not the extension of prior non-conforming structures or uses will or won't be substantially more detrimental to the neighborhood. So the 2019 special permit was applied to a particular project that the Smiths and their representatives brought forward to this ZBA in 2019. And the ZBA decided that that particular project was not substantially more detrimental to the neighborhood, and it approved it. And as the board knows, in its 2019 decision, it said you can build that project. And one of the conditions of that decision was that the project be built in conformance, not with some future building permit or anything else, but with the special permit plans that were part of that project. And as we get into some of the issues, we have copies of some of these relevant materials that we'll ask to put into the record as we present them this evening. So that part of that case has been now litigated at the Massachusetts Land Court. And as part of our ZBA appeal submission in this round, I think it was dated December 15th of 2025, we include a decision from Judge Michael Vey in the Land Court that preceded the trial, where he sort of separated some of the issues. So there were some issues relating to the Two Blossom Lane project that were tried in November of last year, a 4.5 to 5 day trial in front of Judge Vey. And then there were issues that Judge Vey said, for reasons that he explained in the decision that I attached to the appeal this time, would not be heard in that trial, but that could be brought back to the ZBA. So the issues that were tried, just a brief overview, were really three. They were the size of the in-ground pool, the size of the pool house, and the elevation changes to the site. And for the couple of you who were here, and I know you've had many cases since then, so I'm sure it's not like front of mind, but all of those issues were joined and debated thoroughly in front of the ZBA. Judge Vey has not issued a decision with respect to that trial. He may, anytime. We don't know when he'll issue a decision. And none of the lawyers who are involved in that trial, which include Attorney Venkat, myself, Attorney Barry, who I think is behind me on the Zoom.
Yes.
None of us, know how that's going to come out. It could be that Judge Vey says that the ZBA's decisions with respect to the pool and the pool house, which were that the Smiths did not need to reduce them to the sizes that were in the special permit plan. It may be that he says that's okay and that can stand. It may be that he says that the elevation changes that the ZBA did not go as far as we had urged it to go in 2022 and 3 when we had the hearing. He may say that no more mitigation needs to occur there, and that the elevation issues and the grading issues did not require a topographical change special permit, which was the issue in that case. Or it may be that he says that the burns are correct and that the ZBA made an error on one or more of those issues, and it could be somewhere in between. None of us know how it's going to turn out. It may be that you see those issues again based on Judge Vey's decision. It may be that you don't. The 4 issues that he did not have a trial about, and that we're here today to discuss, and I won't get into them in depth because we'll do that later in accordance with the chair's framework, which certainly seems to make a lot of sense, are the pool house use, so as distinct from the pool house size. The judge in his wisdom decided to separate those issues. So we're back to talk about pool house use, which is equipment use, which we say was the authorized use under the 2019 special permit plan, versus a recreational and social gathering use. That's issue 1. Issue 2 are the parking spaces that have been designated by cobblestones on Blossom Lane within the front yard setback of Two Blossom Lane. That's the second issue that Judge Vey said, go back to the ZBA and run through the process there. The third issue is outdoor lighting. And the fourth issue is the second floor deck, which is another issue that, received plenty of debate back in 22 and 23 under a similar argument that second floor deck, and we have, the evidence to show you tonight on this, was not part of the special permit plan that was approved. It was additional structural expansion that worsened nonconformities and therefore needed a special permit. Didn't get one because the plan that was approved set the limitations of what could be built, and it did not include. Yes, sure. Yes. So that's the fourth issue, is the second floor deck. And so we appreciate everyone's, patience and attention with this case, and happy to answer any questions now or later about some of the procedural things that have had us come back here now, many years after the original special permit and several years after the last CPA hearing. Thank you.
Thanks. Ms. Barry, do you have any opening comments you wish to make?
Yes, I do. Can you hear me?
We can, thank you.
Okay, thank you very much for the time. I just want to briefly clarify a couple of things that Mr. Timon said because he's omitted a few things. I think it's important for this board to keep in mind throughout this hearing that this is not an appeal of the special permit you granted in 2019. That appeal became final. Nobody appealed it. The Burns themselves approved it. It was recorded. The project was built. It received the building permits it required. I see that Mr. Orlando is here as well online and should be able to answer any questions you have that way. This has nothing to do with the special permit. What it has to do with is Samuel and Tracy Burns' decision to take a zoning enforcement request to the building inspector to deal with certain things that they didn't like. And what Mr. Timon was referring to earlier was already happened and is done. And Judge Vey in the court decided when he was determining these issues that these 4 issues had not been correctly procedurally raised and he didn't have jurisdiction over them. He gave no decision or impression one way or the other about these things. And the decision that he has before him after trial also has nothing to do with these things. That decision also has nothing to do with the special permit appeal. It was a trial over the Burns request for zoning enforcement that the building inspector denied because certain things had been modified and he had determined that the project was substantially in compliance, and this board upheld his decision. And that's what's before Judge Vey. Yes, a 4.5, 5-day trial on that request for enforcement. It has nothing to do with the special permit. This is not an appeal of the special permit. So what you have before you tonight is Samuel and Tracy Burns' appeal of the use of the pool house, for which there is no special permit requirement. The second floor deck, for which there is no special permit requirement. The exterior lighting, for which there is no special permit requirement. And the area on the Smith's property adjacent to Blossom Lane that is being used just like the Burns shoulder area of their property is being used for decorative purposes in a planter. And it could be used for overflow parking, just like theirs is used for overflow parking, because I'm sure you're all aware, and from the site visit last weekend, that there's no space for parking anywhere on Blossom Lane for your Amazon trucks, et cetera, et cetera. What Mr. Timon didn't mention about the trial that we just had, and that is Judge Vey decides in our favor, both the town's favor and the Smith's favor, is that the Burns have failed to set forth any claim of credible harm to their interests from any of the things they're complaining about. In other words, smack dab before the court is the core issue of whether they are actually persons aggrieved by any of these things. And we feel confident that he's going to say, no, they're not. And that's going to get rid of those items. Although there are other steps after that. But right now, for procedural purposes, Madam Chair, and thank you again for asking, this is a separate appeal of these 4 items, none of which, as Mr. Orlando determined in his decision when he was requested by the Burns to take an enforcement action against the Smith on these 4 items, the lighting, and whether putting pool furniture in a pool house means it's not a shed anymore or some other use, and whether a second floor deck is governed by a special permit. All of those things, that's the core issue for you, is whether this board has jurisdiction over any of these things. That's the real question. Thank you for the time.
Does anybody have questions on the history of the case or procedural things before we get to the underlying items?
From what I recall.
Yep.
The pool house was constructed and then it was larger,
Yep.
right? So that was torn down and it was rebuilt to its current state. I read that today, just want to make sure, because I remember that years ago.
Yeah, that's correct. Should I address that?
Yes, state your name and address, please.
My name is Rodney Smith. My wife, Carla Smith, is here. We represent 2 Blossom Lane. You are correct. There was a slightly larger pool house that was built. That became an issue. We took that down. We rebuilt a smaller pool house under 200 square feet only after the building inspector and the zoning board approved those plans. And we built it after it was approved, exactly the way that it was approved.
And then, so I drove by the property today, obviously there's snow everywhere. The parking spaces, like the letter I'm reading refer to as on-street parking, but that's in fact on the property, it's part of the driveway, correct? It's not on Blossom Street.
That
It's
is,
like an apron.
there's a little nuance. So our property line, which we requested this special permit for, comes out to that stone wall with the decorative iron railings. That's the end of our property. We then own, we share ownership of Blossom Lane with all the neighbors. We own out to the middle of Blossom Lane,
Got it.
adjacent to our property. And that's where we have cobblestone decorative aprons on each side of the walkway to the front door. And we have flower pots on there. There were times when people park there. There are times when people park on the other side of the road. There are times the Burns's service people will park on our side on the cobblestones. So we put flower pots out there. And the Burns also have bluestone or cobblestone, and they have flower pots along that apron. So that those areas that they contend are parking are not intruding in Blossom Lane. They don't block Blossom Lane and they don't go into Blossom Lane.
Thank you.
And then just one last thing. The outdoor lighting, that's, I guess, the issue here. Are those the gas lights along the wall?
I can tell you the outdoor lighting that we have is the gas lanterns on the posts. We also have typical outdoor lighting on each side of the doorways around the property. We have some floodlights towards the back of the house that face the driveway and the backyard and over the pool. And then we have low voltage lighting in the landscaping and in the beds.
Sure.
That shine up on some columns and trees. There's no lighting on the property that's atypical for any residential property. It's all pretty standard. But exactly what they're complaining about, I think it's all of it.
Thank you.
Any other broad questions? Okay. So the first issue is the use of the pool house. Which I think we're all aware of where it's located. Let me just read what the building inspector's decision was, because that's what's being appealed, is what the building inspector said. And his response to the use of the pool house is the accessory structure on the east side of the property was approved as part of the special permit process with the zoning board of appeals in 2019. The use of the structure did not require a special permit, nor were there any conditions in the special permit that restrict the use of the structure. It is my determination that the structure can be used for any customary accessory use allowed in the residential district, and use of the structure is not a violation of the applicable zoning law. Okay? Mr. Timon, let's be somewhat brief too.
Sure. You want to go ahead and speak to the pool house use?
So
Could you just state your full name for the record, please?
Stuti Venkat,
Okay,
attorney for the.
thank you.
So the special permit plans do not mention any pool house. They mention equipment shed. The pool house which was built is about 17 square feet larger than that was permitted with equipment shed. It has a fireplace. I believe it has speakers. It also has seating, lounge chairs. And I have some pictures here. Yes, please. That sort of show the use of the pool house.
For the documents that we hand up to you, Madam Chair, we'd like to enter into the record.
Okay.
And I think in some cases we only have 3.
Thank you.
I just want to request on the record, this is Julie Barry, that Mr. Timon or Ms. Venkat provide copies of whatever it is they're giving the board that wasn't part of their original filing.
Yes,
Okay.
we will.
So, you can see in those pictures, there's, lawn chairs, there's fireplace, essentially a social gathering, recreation space, habitation space. Given the nature of that structure, that is one for entertainment with speakers and fireplace and a place for gathering, the noise that it creates, in fact, has had an impact on the Burns's wide enjoyment of their own property. This place is clearly not for storage of equipment, which is what the special permit says, an equipment shed.
That makes sense.
I do have some videos showing the noise impact and from the Burns properties. I'd like to play and show.
Is that
I feel
necessary?
like the Board of Health. But
Well, we're gonna-
regulate them more.
We're gonna enter the videos into the record.
Yeah.
And you'll be free to look at them.
I mean, people are allowed to use their backyards.
Yes, but the point is, and this is where Inspector Orlando got it backwards when he said, well, nothing in the decision in 2019 prevented a pool house. That's backwards. The decision set the limitations of how a homeowner could expand his prior non-conforming structures. And you cannot build an accessory pool house on a non-conforming lot.
It's not an issue.
Well, no, it is,
No, it isn't.
respectfully.
It is not in the appeal you gave us.
No, pool house use, Madam Chair. It structures and uses, as I said at the beginning. The structure and the size was litigated, where Judge Vay's gonna decide that one way or the other. But use is also something, you cannot extend a prior non-conforming use without a special permit saying, yes, you may have this use. In that case, a pool house that creates impacts. Instead, this board in 2019 said you can have a 180 square foot pool equipment shed to place the equipment. So it's really, and just to step back, you have the Smiths who are here and their counsel who have repeatedly said, what is the big deal? Why are the Burns concerned about this? But please think back to 2019 when it was the Smiths that came to you and their representative saying, this is a limited project. We know we need permission.
Steve, that's not before us.
I understand that's your position, but from the very beginning in 2022 and continuing today, we're saying, correct, we're not appealing the 2019 special permit. We want you to enforce the 2019 special permit. You didn't do it in 2022 and 2023. And we're asking you to do it with respect to these issues that Judge Vay has said are still live issues.
My understanding that the original special permit was with respect to section 6 structures. There was nothing in that application with respect to use.
Right, because they didn't ask for it.
Right.
They don't get it by default. They have to, any expansion of a prior non-conforming structure or use needs a special permit.
But it's my understanding that if the special permit was only with respect to the structure, it doesn't automatically bring the use underneath it.
Right, but it goes in the other direction. Again,
Let me have Ms. Berry speak to this.
Madam Chair, thank you. You are correct. There isn't a use that the board was required to review this for a use. And by the way, Judge Vay dispensed with the difference between pool house, pool shed. It's all referring to a small structure adjacent to the pool, which is a social gathering space that is less than 200 square feet. And under the Manchester zoning bylaw or the state building code, there's no permit required for that structure. I believe it is 197 square feet, and the evidence at trial showed that's the case, and the evidence at trial showed that it complied with the height restrictions that this board had addressed in its previous discussions. So the structure was raised for purposes of lot coverage issues before the board, not whether and how it could be used. That is all something that's come about by way of trying to regulate what the Smiths do in their backyard around their pool. Thank you.
Thank you.
Madam Chair, I'd just like to submit the thumb drive into the record. So these are videos showing pool house use, which is one of the 4 issues. And Judge Bay didn't dispense with anything. He hasn't rendered a decision in the case.
I would like to ask that a copy, or Ben, that you tell me
Yes.
what videos you're referring to, because I can tell the board right now that several of those videos, you can't see the pool house. So they're not relevant.
Yep.
And we ask the board to keep that in mind until I have an opportunity, if necessary, to provide any further information.
After the hearing tonight, Attorney Barry will email you everything that we end up submitting today.
Now, in our decision on the appeal from August 8th of 2022, when we denied the appeal, we talked about the pool shed, and as Ms. Barry says, it doesn't matter whether it's called a pool shed or a pool house, it's an accessory structure. We were aware there was a chimney, a fireplace. You know, and we didn't raise concerns at that point in time, and we approved the structure with the reduced size with the chimney, with the fireplace in it, which says to me, if you're gonna have a fireplace, you're gonna have people in it, and I struggle to find the difference between having a small pool house. It's small, we looked at it, it's not very big, you can't fit many chairs in it, and I don't see that there would be a difference. Actually, I think the pool house would help the noise because they could have the same use on the patio, and patios are not subject to any regulations.
Well, I mean, I think this picture is helpful because it shows, it looks like there's like a roll-up window or a blindfold.
There's
window.
the nano doors.
The nano doors, whatever you call them.
Yeah,
So it looks like these,
open up.
these tables and chairs, they're open to the pool area.
Right.
And by having the pool house there, it creates more privacy and less disturbance for the neighbors. And if that structure wasn't there, then you'd just be seeing a set of tables and chairs out there anyway. So I don't understand how this creates an issue.
Georgia?
Does the pool house have bathrooms?
It doesn't anymore.
Does it have a kitchen?
It doesn't. When it was 480 square feet, it had a bathroom. As part of this process, it was downsized to keep the lounge and the chimney, but it eliminated the bathroom.
In my personal opinion or experience is that with accessory structures, the concern there is after the permit's issued and people go about their day, is that going to turn into an apartment or a second living area, or the in-laws are coming? Are we going to beat this up? Now we have a little guest room, we have a bathroom, we have a kitchen. None of that's happening here. If anything, this is just a stone structure with a fireplace, but I don't know if we're on opinion yet.
Well, and I think that under our bylaw, an accessory structure is limited to residential uses. I don't think this board has ever placed restrictions on residential uses.
You know, if I wanted
Unless
to,
they're excluded in the bylaw for either a primary residence or an accessory structure.
like, if we approved a shed, we're not saying, okay, you can only store wheelbarrows in there. You cannot have a paint, you can't store your paint in there. You can't have a little painting. Yeah, you can't have a she shed. It needs to only, if we are doing that detail, that's way
We've never done that.
overzealous. Yeah, that's not zoning at that point. That's
Okay. Um. Let's go on to the outdoor lighting.
So for outdoor lighting, there's just extensive lighting around the coastal perimeter of the Smith's property. Mainly they have gas lanterns at the front of the property. Those are flickering gas lanterns. There's also floodlights, look like floodlights on the upper level of the house, near the deck, on or near the deck. There's also extensive landscaping lighting.
What section of the bylaw is, speaking to the outside lighting?
That would be section 6.3.4 and section 6.3.5. So for example, section 6.3.5 says flickering and flashing lights. There should be no flickering or flashing lights.
That is a site plan review, correct? The section of the bylaw, that's the site plan review section of the bylaw, is that correct?
I'll have to check that.
I have the file.
It's, it's my understanding it's a section that was added after the special permit was issued. And the site plan review was not required when the special permit was issued. And it's my understanding that the resident can add any type of outdoor lighting they want anytime they want, which doesn't require a building permit, doesn't require a special permit. So you wouldn't need a site plan review unless you were applying for a new special permit.
Right, 6.4.3 is in the special permit and site plan review section of the bylaws. Our position with respect to the lighting, it goes back again, and I realize that you have stated you disagree with this, but when the applicant, the Smiths, came to this board in 2019, they had to come hat in hand and say, here are the things we would like to add to our property that will make this project not detrimental to the neighborhood. And if they wanted, lighting, which would be as obtrusive as it's turned out to be for the neighbors, they should have put that in their site plan, because the special permit in 2019, which we are again asking the board again to enforce, said you can have your expansion project, but it must be confined to this plan that we, the ZBA, has decided is not substantially more detrimental to the neighborhood.
And I'll disagree with that. I think that when we review a special permit, we're talking solely with respect to the structures. We're looking at changes in footprint. We're looking at adding masses to existing non-conforming structures. We are not looking at lighting on a residence. We never have. And, so I don't think you can argue that the lighting was part of our special permit. Ms. Barry, do you have any comments?
Thank you, Madam Chair. No, not really. Just to say that to reiterate about the bylaw not being part of applicable at the time of the special permit, and also, that there's no flashing or blinking lights, so those wouldn't be applicable anyway. You don't call a gas lamp a flashing or blinking light. We're clearly referring to something else. So the board, I agree with the board that it doesn't have jurisdiction over this.
Let's move on to second floor deck and balconies. I'm sorry. Go back to Mr. Orlando's decision on outdoor lighting. He says the provisions of section 6.3.7 of the zoning bylaw cited in your enforcement request were not included in the zoning bylaw at the time the project was permitted, and therefore are not applicable to the project. The next item is the second floor east deck and balcony. And Mr. Orlando says the second floor east deck and balcony are shown on the plans approved for the building permit granted on August 13, 2020. Your request for zoning enforcement now is not timely. Additionally, the deck is not a substantial change from the plans approved by the ZBA, nor does it increase the non-conforming nature of the structure. Mr. Knight.
The special permit plans that were applied for and that were approved simply did not depict the decks. There are the plans that we'd like to circulate.
So these are the special permit plans that were submitted to the board. That board's decision in 2019 said needed to be reported with. And then the single sheet is the site plan itself that was the special permit approved plan. And the application plans show in the elevation, and we've gone over this before, the board showed really that what you just read, Madam Chair, from Inspector Orlando about what the special permit plan showed for a deck and that it didn't depart or something from what's there, is completely not the case, because as you can see in the special permit plans, there is a sloped roof shown on the eastern side of the building, and instead there was a deck built there. And this board said to the Smiths, you could build this project according to these plans. That would not be substantially more detrimental, and they built something else.
But in our decision with respect to the prior appeal, we stated house with respect to front setback, rear, in which we denied the appeal, rear setback and roof height based on a finding. The dimensions are consistent with the 2019 special permit, and the east second floor deck and design are consistent with the approved August 2020 building permit, neither of which was appealed.
Right,
So we addressed the fact that there was a second floor deck,
you did, and we appealed that decision in 2023.
but the court wouldn't hear it because they said they didn't have jurisdiction.
No,
So
that's not the case. The court said the trial that we had in November was on our appeal of your 2023 decision. And in the, as is shown in the pretrial decision that I attached with this appeal, Judge Vey said, with respect to the 4 issues, I'm not going to hear them as part of this trial, and he explained why. But he said they are dismissed without prejudice, and then he further clarified before the trial that we could do exactly what we're doing now and exhaust our administrative remedies anew by going to Inspector Orlando, and then here we are coming to you. So this is all part of the appeal of the 2023 decision, which declined to enforce your 2019 special permit decision.
is there any difference between what was submitted and what was built other than the addition of a railing?
Yes. Could I borrow that? Have that for a second? Thank you. If you look at the plans and you go to the 3rd page, the south exterior elevation. Again, these are the plans that the Smiths and their team submitted to get the special permit in 2019, where it says bold outline indicates envelope. So as you can see, that is very clearly showing a sloped roof going
Not
down.
very sloped.
Well, it's certainly not a deck. It's not any deck that I would ever want to stand on, or I'd end up on the ground. So that's not a deck. And so it's not just about an addition of a railing. It's about a second floor deck that was installed that creates certain privacy issues that we've talked about before, and that was not authorized.
Madam Chairwoman, can I address one issue?
Go ahead, Mr. Smith.
Just to clarify, the plans that you're looking at in that sloped roof, that is the original house that was there, not the proposed house. And when the architects put the lines around, they were showing the envelope of what was going to be constructed, which basically showed that the entire original house was going to be touched. and it showed the new footprint of what was going to be built. But that structure you see is the original house, not the detailed plans of what was going to be built within that envelope that they put the dark line around. So that sloped roof is the sloped roof of the original house, not the new house.
And there is no quote unquote detailed plan that ever showed a deck as part of the special permit proceedings. It was-
Actually, it's called a building permit plan, as
Right.
Mr. Orlando referred to in his decision, and the special permit, there's no special permit requirement for a second floor deck. Every house in the neighborhood has one.
Okay, well,
The other clarifying point that I would make is if you look at the plans, you'll see on the east side, there is one of those dark bubble lines that comes out on the east side where the deck is, that shows the envelope of what would be a roof over a door. Because the deck was gonna be built there, and we showed where we would have a bump out that would have the covering over the door. So again, it was just a rough design of the original house with the outline of where the construction would happen.
Now, you also referenced balconies. When we were on the site visit, what we saw was a roof with a very shallow exterior detail around the roof. We did not see any balconies. What balconies are you referring to?
I mean, I think I'm talking about it, but yeah, if we call it a balcony, it's synonymous with a deck. I'll point out as well that we, for the record, I think this is important to have in the record, that we did request of the Smiths through their counsel that the site visit that you conducted on Saturday include a walk up to the second floor deck. And the Smiths counsel refused our request to allow that. So
Chair
we did-
Mellish, I'd like the opportunity to
We did want you to
respond to
see it.
that.
Okay, yes, Ms. Berry.
Thank you. This board conducts its site visits at its discretion and under its authority. They are supposed to last approximately 15-minute long. They are noticed to the public, and that means anyone can attend. This is not our appeal. It is the Burns appeal. And what my clients can see out their window is not relevant here. And Mr. Timon knows it. That was an effort to harass the Smiths, because there's no reason, and with all due respect to this board, there's no reason to have people tromping through their house for Mr. Timon's appeal on behalf of his client. We had a discussion about that. I said I didn't want this board being given any direction as to what it could or could not see. And yes, we did not agree to people walking through the house.
And I will say that, the ZBA site visits, we never go into houses. They're always external site visits.
Never happened.
Right. Okay. Parking spaces on Blossom Lane. Oh, wait a minute, hold on, let me read what the building inspector said, sorry. Mr. Orlando said, nothing in the zoning bylaw at the time the project was permitted or now requires any approval for parking on Blossom Lane. Of note, section 6.1.5 cited in your enforcement letter was not in the zoning bylaw at the time the project was permitted. In any event, that section applies to off-street parking and provides parking is allowed within the driveway for residential uses. The driveway has been constructed in accordance with the building permit issued on August 13, 2020, and related plans, and your request for zoning enforcement now is not timely.
And so, and I know Ms. Venkat will follow here, but there, unfortunately, Inspector Orlando, with all respect, completely missed the boat, because we're not talking about the driveway. We're talking about the quote unquote decorative parking spots that are in the front yard setback of the and as part of the Judge Bay decision pre-trial that we submitted with our application, he indicated that a reason why he didn't believe the parking spot issue was ripe or within his trial jurisdiction at that time was because they hadn't been fully built out at the time of our earlier proceedings. So here our argument is twofold. One, the one I've made repeatedly tonight and basically since 2022 about what wasn't, what the limitations of the special permit decision were. And secondly, that when the parking spots within the front yard setback of the Smiths were put in, they were governed by bylaws that we've cited in our papers that prohibit parking in the front yard setback.
I thought that the property line, for purposes of calculating all the setbacks used, was kind of in line with the granite posts at the end of the driveway, and therefore just a few inches in front of the front stone wall. If that's the case, then this parking would not be within the front setback. It would be along the street, which would not be covered under the zoning bylaw. It would be on street parking.
Well,
Looking at, sorry, I just wanted to compare this plan you gave us. I'm looking at the property line here. It looks like these two square columns that are marked on the plan. I'm just trying to correlate it with the photo. Would that be the entrance to the?
Yeah, there's a stone wall there.
Yeah, so I think these two are these two, and they're beyond,
They're
inside the
No.
property.
they're on the street side of the stone wall. The stone wall goes along here, and the parking spaces are here,
Okay, got it. Yep.
Here, and
on the street side of the stone wall.
All right,
We couldn't really see them because the snow was covering.
got it.
They
Okay.
weren't allowed.
but your point, Madam Chair, it doesn't, it doesn't cure. Even if I were to agree with you, and I don't, I think that the center line of Blossom Lane is the Smith Zone up to the center line. But even if I agreed with you on that point, it doesn't cure the problem that the special permit, again, needed to have approved the things that would increase nonconformities. The other point I'd like to make briefly on the parking spots, during the trial, at some point during the trial, the Smiths began putting planters in those spaces. And I think, it seems to me that given what I'm hearing from the Smiths about these being decorative, these being spaces that apparently they claim they don't intend to advertise as parking spots, then it shouldn't be that big of a stretch for the board to strictly enforce the rules as we've laid out and say that there shouldn't be parking there. I also want to point out, and the members probably know this from either the site walk or just knowing the street, that this claim that somehow the Burns visitors and guests park there is completely bogus. The Burns have ample parking on their larger lot.
In the front setback.
I'm sorry?
In the front setback.
Well, no, it's,
Their parking goes all the way to the stone wall.
yeah, but they didn't ask to do an expansion that required a special permit. Those are all grandfathered uses. So
We don't rule on any landscaping, anything like that. Our special permit is with respect to the structures. Not with respect to landscaping, parking, or anything like that. So for you to say that the parking was part of the special permit, I would respectfully disagree.
okay, well, we'll agree to disagree, but I do want to point out that this is not a place where anybody going to the Burns property is parked. These are spaces directly in front of the Smith property that they've put there, as with many other things, to sort of, beg forgiveness rather than seek permission. And those are spaces that are used for guests of the Smiths. And in the summertime, they invite other people to park there on a road, Blossom Lane, that's already quite narrow and difficult to navigate for people on that street, including the Burns, when there's.
Madam Chairman, we do have photographs of the Burns landscapers parked on those cobble
Okay,
spots, and if you want to see them, would be happy to.
I don't think it matters. I really don't think it matters, what that space is used for, who parks there. It's, it's whether they're covered with a special permit. Ms. Berry?
Yes, Madam Chair, it's Julie Berry. Thank you. I agree with you. I don't think that it matters. And I think that Mr. Timon is stretching here to try to drag this within the ZBA's authority. And in fact, he's incorrect that Mr. Orlando dropped the ball. Mr. Orlando addressed the issue that would be part of the zoning determination as to vehicle parking, which is the driveway on the property, which was constructed correctly. There was never any complaint about it. The building permit was never appealed, and it's too late. The cars are parked in the driveway. That's what the driveway is for. There's no reasonable dispute about that. And Mr. Orlando correctly addressed the only thing that could be at issue before this board, which is the driveway in the context of the board's decision concerning lot coverage and those types of issues. It certainly didn't have to do with the use of a space outside of the setback.
Thank you.
Thank you.
At this point, I'm going to open it up for public comment. Is there anybody in the room who wishes to speak on this application? Is there anybody on Zoom who would like to speak on this application? If so, please raise your hand in Zoom. I see no public comment. I will at this point ask the board if they have questions as part of this public hearing. No questions. So we're ready to close the public hearing and move to deliberations?
Yes.
I make a motion.
Okay.
Close the public hearing.
Georgia makes a motion to close the public hearing and lead to deliberations. Do I have a second? Second. Colleen seconds. A roll call vote. John?
Yes.
Georgia?
Yes.
Colleen? Yes. And Sarah votes yes. Okay. We have the 4 issues before us. Let's go through them one by one. Pool house use. What are the thoughts?
I think if we're regulating what we're doing with an accessory structure, if it's not asking to be an accessory dwelling, an ADU, there's no occupancy permit for it. We shouldn't be regulating what people are using accessory structures for, whether it's storing shovels or pool equipment. If there's speakers on that accessory.
I agree.
And what I had written in my notes, I think the noise complaint, if people are outside and being too loud, then I think that would be, in my opinion, a Board of Health concern. If you think those decibels are being reached and that it's a hindrance to live in the house and have people in the pool outside, then.
I think reality is this town does not restrict people's use of their property.
It's like me, yeah, yes.
That's it.
Unless you're hiring Metallica to play in your backyard.
But in my mind, it's commercial, it's a residential, it's not like you're asking for a new unit, a living unit. The use of whether they're in their driveway, their car, or in the pool house isn't
We could be
changing.
on the path.
Yeah.
The same use.
Yes, exactly.
Which is not subject to anything.
Mhm.
And I agree with what everyone's saying. I mean, you're beside the pool. You can have people around the pool and making noises and stuff. So I think the use that how you're using it is fine.
Well, and I think that the thing we have to remember is that the special permit that came before us was to deal with non-conforming structures and a non-conforming lot. It was not to deal with the use of that lot. It was a residential use, non-conform, it's a conforming use. It's a residential lot being used for residential. I don't see what use has to do with the special permit. We issued as long as it's a valid residential use.
So I'd argue I agree with Mr. Orlando on that point.
Okay. Outdoor lighting. So this one is under our current bylaw. If one submits for a special permit, there's now an added requirement of a site plan review, which used to only be with the planning board, and now it was extended to all special permits. But it only applies if you apply for a special permit. And it didn't exist when, in 2019, when this special permit was issued. And my understanding that I can install an outside light at my house and I don't need a building permit and I don't need a special permit. Therefore, the site plan review would not kick in because I'm not applying for a special permit.
I would agree on that. And from what I've seen in the bylaw, we don't have a lumen count, we don't have types of lighting, we're not a dark sky community, we're not. So, and I had put in my notes that I do appreciate the gas lanterns, they're less lumens than the regular LEDs. The house does have LEDs, one of them seems a little bright on the deck. But again, that's not something we regulate. My neighbors turn their headlights on when they get home, but they turn them off, it's not, so that would be my opinion on, it's not.
John?
Yeah, I mean, there's nothing out of the ordinary here. I think those gas lanterns look amazing, actually. I think it's a nice touch. And the uplighting on the landscaping, I mean, it's so common around here. It looks great. It makes the house. I have no issue with it.
I'll have to say, we looked around for lights when we were at the site visit, and we had troubles finding. When we stood on the street, we were standing in the street, and we saw the gas lights on the posts and at the door, and we saw the light over the little portico on the deck, and we didn't see any other lights.
No,
right, Colin?
No, we didn't see any.
Second floor deck and balconies. So it seemed clear. At the site visit, the only thing in question was a small deck on the second floor, which is to the front on the left side. And it was on the building permit. The building inspector felt that it was a de minimis change. It didn't impact the ability to issue the building permit, therefore wouldn't be a violation of a special permit if it's a de minimis change. I think that you never expect what's built to be exactly what comes before us. It is supposed to be substantial. In agreement with the plans.
I'd agree, if he didn't find it substantially different than what was approved and was de minimis. It still has the same setback, it still has the same length, but. What it's used for carved in the middle, like, makes no difference.
John?
I agree.
Parking spaces. I think that it's difficult to have an argument that the lot line is in the middle of Blossom Lane, and therefore this parking is in the front setback, if you're not using the middle of Blossom Lane to calculate the setbacks for the structures. And it's my understanding that all the setbacks for the structures are based on a lot line, which is the property side of the right of way along the road. If there's a road and a right of way, And that the stone wall is along the property line. The lot line. Which would mean that this parking is on the street, not in the front setback.
I would agree.
Which is what's in the new bylaw. It wasn't in the bylaw when
Okay.
the 2019 special permit was issued. It's part of the site plan review, I think. And I'm not even convinced it's parking.
Well, I also think it's actually for the better of the neighborhood to have a little relief. People go down there, there's 3 houses down there, they make a wrong turn, whatever.
You
or
can't, yeah,
People show up, they don't know whose driveway to pull into, at least just space to stop and figure things out, you know? Which is probably why the neighbors have visitors park there accidentally or whatever. You know, the gate's not always gonna be open to let people in, so. I mean, I don't see how it hurts the neighborhood.
I agree with that.
And the fact that it wasn't plowed says to me that it's not. Highly,
A daily, yeah,
or in my mind, like, what's the difference between, what if someone on the street had a graduation party that day? And one side of the street, I know it's a
What
very
parking
narrow
grass?
street, or you know what,
Difference.
one of the houses had a wedding and people were parked out, to my sense, it's no different. We shouldn't be regulating who's parking when.
well, and the zoning bylaw does not regulate on-street parking.
Yeah.
And our responsibility is with respect to the zoning bylaw only. If there's an issue of parking on a street, that's a police enforcement issue, it's not our issue.
And also a private street at that matter. I think that adds another layer of,
Right.
that's.
So you ready for, so that, are we in agreement that we wish to deny the appeal?
Yes, I agree with.
Yes.
Mr. Williams then.
So you ready for me to make a long motion?
sure.
I move to deny the appeal filed with the town clerk on December 15th, 2025, and uphold the enforcement officer's administrative decision dated November 13th, 2025, based on the following findings. Pool house use. The board finds that only structural relief, not use regulatory relief, was requested from the board in the granting of the 2019 special permit. The structure label on a plan is irrelevant, and the revised plan approved by the board in its decision denying a prior appeal filed with the town clerk on August 8th, 2022, included the fireplace and chimney. Under the bylaw, an accessory structure is limited to residential uses, and the board has never replaced restrictions on those uses. You agree with that? Outdoor lighting. The section of the bylaw cited by the applicant requiring the site plan review was not in effect when the special permit was granted in 2019. Under the current bylaw, a site plan review is only required in conjunction with an application for a special permit. The installation of exterior lights by a property owner requires neither a building permit nor a special permit, and may be installed without any need for adherence to the factors considered in a site plan review. Agree with that?
Agree.
Second floor deck and balconies. The board finds that on the on-site visit, it was clear that the alleged balconies were merely low decorative trim around a relatively flat roof, not balconies. There is a small second floor deck with railing on the second floor. Although the railing was not depicted on the ZBA permit set, it was included in the building permit application. And the board finds the addition of the railing is a de minimis change from the plans approved under the special permit. Is that sufficient?
Yes.
Great.
Parking spaces on Blossom Lane. The board finds the lot line is at the front of the granite pillars and a few inches in front of the front stone wall, consistent with all setback calculations used in the special permit and building permit applications. The alleged parking spaces are along the street in front of the stone wall, not in the front yard setback contained in the bylaw. Furthermore, the decorative pavers in front of the stone wall are part of the landscaping plan and not necessarily parking spaces consistent with other properties on the street.
Great.
I will take a second.
I second it.
Georgia seconds. Any discussion? Vote. John,
So to be clear, the original motion was you.
denial. Denial of the appeal.
So I approve the denial of the.
Upholding the the enforcement officer's administrative decision.
Yeah, so I approve the denial of the appeal. So yes.
Okay. Georgia,
Yes.
Yes.
Kelly, and Sarah votes yes. With that, the appeal is denied.
Appreciate your time. We'll email the clerk PDFs of the things that we submitted into the record in paper.
And I'll write it.
Thank you, Madam Chair.
Okay.
I'm gonna use the mental report.
Okay.
Who do us?
I still haven't texted Rob, so George is from Murphy Hesse, or no, I always say Murphy Hesse too, but it's not, who is it? Who's our town council?
Thank you for being so patient.
Local drama. I've got a hint here.
Only two of us here for 2 weeks tonight, so that was pretty good, and I'm like,
Yeah. Want us to next to Joe?
We're just taking a brief moment for
Sanity.
members of the board to.
Feels like.
Oh, Steve.
Oh, so sit there, so I'll sit. All right, I'll sit.
Yes, so.
Comfortable.
What?
Nothing.
Oh,
Main Street. Suddenly, Pleasant Street.
that's one more. Okay. We're now moving on to Pleasant Street. And one of the things I just want to make clear is that it referenced 70 Pleasant Street on the application, but this is one lot that contains both 68 and 70, and it's actually 68 Pleasant Street.
So 70s in the back?
yes,
Okay, I just wanted to clarify that. But the assessors map number and the lot number. All right.
Okay.
Okay. I move to open the public hearing for the application of Karen O'Cone for special permits under section 7.2 and 12.5 of the zoning bylaw and or other relief as may be necessary to add 1.5 stories on the existing footprint of a single-story non-conforming residence and add a 6'5" by 10'5" rear addition to accommodate a stairwell on a lot containing 2 residents, number 68 and 70, at 68 Pleasant Street, assessors map number 41, lot number 54, in District D2/B, filed with the town clerk on January 28, 2026. Do I have a second? To open the public hearing.
Second.
Thank you, John. Vote to open the public hearing. John,
Yes.
Georgia,
Yes.
Colleen.
Yes.
And Sarah votes yes. With that, I would like, are you gonna present? Would you state
Yes.
your name,
My name
please, and
is-
your relationship?
My name is John Andrews with JFA Design Group. I'm the project manager on the project.
Okay.
Yeah, I can start. So what we have here is we have a single-story dwelling that has 2 bedrooms, 1 bath, about 760 plus square feet. What we'd like to propose is a second story on top of this to increase the square footage. That'll also increase the bedroom size for 3 bedrooms. We have a rear proposed addition, like you mentioned, it's 6'5", 10'5", in the back of the house. And that's for a mudroom/bathroom. So we have, why we're asking for the relief is we have the mom and dad and 2 kids here. Right now, we only have the 2 bedrooms. We also need the size. So even with the increase of the second story, we're only at about 1,600 square feet. As far as beyond the footprint, the only thing that we're adding beyond the footprint, if you can see on the plot plan, is the proposed addition. That's just in the rear. There is 2 1-foot decorative overhangs, but they do not have a foundation. And so as far as roof area, drainage and stuff, it remains just about the same except for that small 70 square foot addition in the back. All of the existing plans are marked EX, so EX1 through whatever, so you can see what was there. And then all the proposed plans are A1 through, let's see, A8. There was a comment made by some of the board members that came out and looked at the property about a 3rd level. This is just an attic level there. Part of it is decorative and the other part of it will be for storage. So it's a 4-foot high wall that's up above the existing wall. And then, of course, there's the hip roof above that. So when speaking with the building department, Mr. Orlando, he mentioned 2/3 of the space inside of this attic can be used at a full height. So when we did our calculations, we came up with 203 square feet of that area that we would use. Again, it has a walk-up staircase, but that's mainly just for storage at this time. And the windows there, or the big part of it, is decorative.
Is there any way to pull those walls down to less than 4 feet?
I can make it 3'6" if that has to be under, sure.
Yeah, I mean, the height definition in Manchester.
Yeah.
Is 2.5 stories.
Okay,
So it doesn't bear any relationship to how it's used per se.
sure.
And if it's a 1/2 story is defined as
50% of the space that's below.
2/3
Oh,
of the
2/3.
space at a wall height of 4 feet.
Okay,
So if you were to drop the wall height down to 3'6", then I think would be okay.
that would be. Yeah, and that's, we can absolutely do that.
Was that intended for storage space?
Yeah, exactly, because what happens is, well, you've got the pitch of the hip roof. So when you sort of come up, by default, you have that open anyways. So you can come out there and have some storage space.
Right.
That was it, because in the basement here, this is an old fieldstone basement, and the height varies from 4 feet to 6 feet. It's all over the place. That'll have to be shored up. So we don't want to take down the whole building. What we want to do is just shore everything up, work on the first floor. And then if we have to stud those out to be 2x6 studs and then work our way up to the second, it will be fine for insulation. But we just don't want to, take down the whole building. Want to leave it the same footprint in the same location. All the other requirements meet within the building code. We realize too that when it's essentially going to be a new building, by keeping this footprint and then, like I said, keeping the first floor walls. So everything else will be brought up, HERS rating, installation, structural engineering will be done on it. And I think that's just about it. This has been a dwelling for a while, so it's not a converted garage or anything like that. It's always owned by the town.
How long have the two structures been on the lot?
Well, we've been there since 1980.
They were built in the 40s.
Both structures. Okay, okay. Well, this house is in D1. So it could be a two-family, but under the D1 two-family, they have to be connected. So that's why, I believe, so that's why it's non-conforming. It's because they're two separate houses on the lot.
We also thought about the ADU of it. It was at 900 square feet, or half of what the main house would be, right? We just needed more space. That was a big deal.
We're hearing that.
Parking's
Are you
okay.
hearing it? Currently, under our bylaw, though I hope it's gonna be changed at town meeting, an ADU is not allowed in District D1, a large ADU. Just the 900 square foot, so I've asked them to change that, because we had one good, we had to deny, we couldn't approve. Questions from the board?
I think that's nice.
I appreciate the streetscape we were given. That's helpful.
Yeah, because that was the first concern when we took the project on, is what is it gonna look like with the rest of the homes? So we wanted to keep that into a certain height.
And we did receive a letter supporting the project from Peter and Althea Sargent at 72 Pleasant, which is the house on the right.
Yeah, so
Oh, next to it.
Is there any member of the public in the room who would like to speak on this application? No? There's nobody on Zoom, except for the town planner. I don't know, they all left.
no pool house.
Yeah. I did just also want to I have to throw it out, but knowing you could do what you could do, you're still under the lot coverage allowable amount, and you're still under the lot coverage impervious coverage amount, which is
Right.
always nice to see.
Yeah.
You could have gone for the full gamut, but kept
Yeah,
it.
we're kind of sticky at that.
Yeah.
That might come up. Yeah,
You know, we have such a high water table that.
it is. That was mentioned last two.
Yeah, the coverage is really important to us. And it looks like in the this is a D2, I guess it is, not D1. That it meets all the setbacks in D2.
Yeah.
Anything else?
Nope.
You ready for me to close the public hearing? I move to close the public hearing and have the board enter into deliberations with respect to this.
Second.
30 seconds. Vote. Done.
Yeah.
Good.
Yes.
Colleen?
Yes.
Sarah? Yes. Discussion board.
I'm fine with it.
Fine with it?
Me too.
Thank you.
I will make a motion. I move to approve the application of Karen O'Cone, sorry if I mispronounced it, for special permits under section 7.2 and 12.5 of the zoning bylaw, and to other relief as may be necessary to add 1.5 stories on the existing footprint of a single-story non-conforming structure which conforms with all required setbacks, and add a 6.5 foot by 10.5 foot addition to the rear on a lot containing 2 residences, number 68 and 70 at 68 Pine Street, assessors map number.
Pleasant Street.
Pleasant Street.
Pleasant Street.
Thank you. 68 Pleasant Street. I've been calling it Pine Street all along. 68 Pleasant Street, assessors map number 41, lot number 54, in District D2/B, filed with the town clerk on January 28th, 2026, based on a finding the proposed project is in harmony with the purpose and intent of the bylaw, will not be substantially more detrimental or injurious to the neighborhood in which it is located than the existing non-conforming dwelling, and the requirements under section 12.5.2 of the zoning bylaw for the grant of a special permit have been met based on the following conditions. The addition is located as depicted on the certified plot plan prepared by Northern Associates dated January 23rd, 2026. The attic the half-story attic shall have an exterior wall height of 3 feet 6 inches. The project is constructed substantially in accordance with the following plans prepared by JFA Design Group, filed with the town clerk on 1/28/26. Now that the hard copy of the plans I have, I think one is misnumbered.
Oh, it is?
Yeah, I think the second one says A3.
Oh, yeah.
should be A2.
A2.
Okay. So proposed elevations A1, A2, A3, and A4. And proposed floor plans A5, A6, A7, and A8. And existing elevations EX1, EX2, EX3, and EX4. And I don't need to include the existing floor plans in the decision. Do I have a second?
Second.
John seconds. Any discussion? Vote, John,
Approve.
Georgia,
Yes.
Colleen,
Yes.
and Sarah Roches. I'll write this because everyone else is so slow. Who would like to review?
I know, I was, I didn't, I'll review.
Okay.
Just send me both.
Thanks, Sarah.
Yeah, thank you, Sarah. And I finished mine yesterday.
You're all set.
Thank you. Thank you.
Thank you. It can take us up to 90 days to write the decision. Because we're slow.
But it won't.
Hopefully it will be, if we have a lot more snowstorms, it may be quicker than that.
And you need, I can write it.
No, honestly, I can write that.
Yeah, we can step in. Just let us know.
Just one question. Is there any kind of appeal process that we have to make for as far as 20 days or anything like that, or?
Yeah, so what happens is once we write the decision.
Yep.
We'll file it with the town clerk.
I see.
And there is a 20-day appeal period. The building inspector will issue a building permit before that 20-day appeal is up, and you can build at your own risk.
I got you.
Okay,
Thank you.
so if, and we'll try to be quicker, because I know we might be getting to building season pretty soon.
Yeah.
Thank you.
Thank you so much. Sorry for the wait.
Yeah, hi, John.
Tanya.
So much.
Thanks,
Thank you very much.
That's your.
Thank you. Thank you.
Josh.
Yeah, I remember Josh, yeah.
I'm definitely happy to.
Hope you learned a lot.
Okay.
She sat there for an hour.
Until Kendall,
He was really excited.
You'll write this one?
Yeah.
And then halfway through that, he was.
Sorry, it took so long to get to us.
It's interesting, it's really nice.
Yeah, thank you.
Much faster than minutes.
He's really good. He's very good.
No.
You never know if you're gonna.
No, that was a boy.
What?
No, it's a female, it wasn't I.
Female.
No.
Kendall.
Kendall.
Oh, I thought it was a.
Is our again? I was the land clerk, administrative assistant.
Got it.
She's
Is he on right now?
female.
Oh, okay.
No, she doesn't, she takes it all off of the
Yeah.
recording and then
She watches the.
they use
YouTube.
AI.
Yes.
They're all using AI now. Okay.
Why not?
He's an officer. I looked.
I know we're still.
Okay,
Sorry.
Just gossiping.
You catch my hand. Sorry.
so where's my page 2 of my agenda?
I know.
Not real.
I don't need print up yet.
Wait a minute, I'm on the wrong date.
I-
Wait a minute, hold
Yeah,
on.
the one other,
Yeah, we have another.
Five members, no agenda, look at that.
What?
I said 5 members. No, well, mine's on.
I like those flickering things.
The glass, the lanterns are so cool. Literally, I went by at night and I
There
was
isn't
like,
anybody on, right?
no, there is. Well, we don't know. I mean, it's watching
Okay.
from home, so
So
I'll get the agenda right now. I have it right.
the next item on the agenda is with respect to 14 Coolidge Point. And this is a request for a determination regarding a de minimis change to our special permit. The issue behind, the story behind this is they applied for a special permit in 2023. It was not written correctly, so it was supposed to expire after 2 years, so they came back to us and we extended it for another year. And it's due to expire, April 10th, 2026. The homeowner is in Madrid, Spain. And I chose not to require him to attend due to the time difference. And he sent us an email, which I think everyone received, which laid out what he's trying to do, plus he sent copies of what was originally submitted and changed. Now, when I looked at it, the design is completely different. He is an architect, which means,
The
but
Tower House?
what?
Is this the house at the tower?
Yes, the
Yeah,
old
right.
World War II tower.
Yeah.
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 I remember that.
So where is this?
So
Is it
the
on Maskinote? Is it?
No, no. it's
No.
not the one.
Coolidge,
Okay, oh, yeah.
it's on Coolidge.
There was an old World War II,
Like a little,
Correct.
I mean, was it just a cement?
yeah, the big cement
Tower, yeah.
ugly thing.
Yeah, I remember.
Yes.
Yeah.
Yeah.
I remember this.
Yeah.
I was
When it
there.
came on the market.
Yeah. And so he, what he has explained to us that, they're trying to break ground so that we don't have to issue, they don't need to apply for a new special permit. And they submitted the building permit application. And Paul Orlando suggested they come back to us and have us make a determination of whether the changes are de minimis. And the changes although the design's different, the changes with respect to footprint are the height. They've reduced the peak height from the approved 35 feet down to 32 feet, 11 inches. They've created better buffers. They've increased the side setback, moving from 20 feet to 23 feet in one of the setbacks to give their neighbors more room. They adjusted the location of the garage for better driveway flow and preserved more pervious green space while staying strictly within all zoning setbacks. So it's a non-conforming lot is the problem. And they said, since our applications, our neighbors relocated their parking area close to where we planned a kids' play area in front of the previous garage. So we decided to give them and us more privacy by removing that area and shift the garage to its new location. And he said the house remains a 3-bedroom cottage shingle style residence, just as originally proposed. The design also wants to be more in line with the buildings in the area, and we see it as a better interpretation of the town's goals for high quality architecture than the previous version. So what the table of changes reflects, so the lot size is 19,863 and the minimum is 90,000, which is non-conforming. The special permit we approved was a gross floor area of 3,900 square feet. This design is 3,730 square feet. Lot width, lot frontage doesn't change. It's short, small. The front setback is 30 feet, which is what the zoning requires. The side setback, the zoning requires 20 feet. We originally approved 15 on the west, 20 on the north, and 17.9 on the east. The new design is 20 on the west, 23 on the north, and 20 on the east. So it's now conforming with setbacks. And the building height was 49 feet, and now it's 34 feet, 10 inches, where 35 is the maximum. And the building lot coverage is now going to be 2,220, no, is currently 2,223 square feet, and we are asking for 2,658. The maximum of 15%, which is 2,979. So they're under the 15% coverage by structures. And impervious surface is going to be, total impervious with the building is going to be 2,302, and the maximum is 4,966.
I like it.
So, and,
I have the agenda.
Oh,
I
yeah.
have it back. Taking the time with him?
yeah.
Whatever.
The kids can jump on.
And he included a descriptive narrative that was in the original application. And then the building permit application is very confusing. The house is a different shape, but it's relatively the same square, it's relatively the same footprint. Towers being eliminated.
No. Cool.
An interesting talent.
Yeah.
Just keep it intact, move it to my property.
Kids playground.
With some tower, wasn't it?
Yeah.
Looks like.
It's like very concrete.
Yeah.
Yeah.
It was a sub tower. Brian Kelly had one, but it was,
Yeah, it's still up there.
Different.
It's taller.
Yeah, his is,
That's the White
yeah.
House.
that's a
It's
lot.
basically what
But
I
it's
tell
a,
people
it's
is
actually a
like-
sub tower though, I think.
Yeah.
Yeah, this one was.
Ever been in, I
Yours was a tower.
who, Kelly's?
Yeah,
Oh, yeah.
this was a
Yeah,
barrack.
nosebleed,
It's more like Soviet style.
Yeah.
Yeah, this is like just slap it together, throw it in.
The cargo building.
Yeah.
Yeah.
So. Are we okay
Yeah.
with
Yes.
this being a diminutive change?
I agree, it's getting more conforming than it was.
I mean, I think, you know, what we tried to argue. Awesome, is that, you know, we're not really approving the design per se, we're really looking at footprints. And mass.
And so, yeah.
And this seems to be addressing that. Okay, so I'm gonna make a motion. Make this up. I move to confirm the zoning board of appeals determined the plan submitted on, I think it's December 30th, 2025, requesting a building permit, include de minimis changes to the plans included in the special permit granted on April 11th, 2023 for the property at 14 Coolidge Point, assessors map number 3, lot number 11 in District E, and authorize the chair to notify the building inspector of its decision. Do I have a second?
I'll second it.
Colleen seconds.
I need to have some fun too.
What?
I said I need to have some fun too.
Go Colleen.
Vote, John,
Yes.
Georgia,
Yes,
Colleen.
Yes.
And Sarah votes yes. Okay, I'll send an email to the building inspector and to the property.
thank you, sir.
Okay. Next item on the agenda is approval of the minutes from January 28th, 2026.
Make a motion to approve the minutes of January 28th, 2025,
26.
2026. Sorry,
Do I have a second?
Genesis 20.
I'll second. All this was, in case you forgot to look at them, is a continuance of 2 Blossom Lane.
Yeah.
It was an easy one.
Take a vote. John,
Yes.
Georgia,
Yes.
Colleen.
Yes.
And Sarah votes yes. Next is outstanding decisions. We still have 38 C Street, do we not?
I have that one. Yeah.
I think the deadline is,
Boy.
it's March 15th, I think.
I'll write it this week.
Yeah,
Yeah.
I
I'll be
heard
done
that
this week.
this meeting.
What's that? Busy.
I heard that.
Yeah, then the. And
And then
then,
life came.
and then I saw the homeowner at Laughing Gull. I was like, do you need that? 4 feet of snow.
I followed you.
And I've got 22 Union, so I can't give you too hard a time.
Yeah, I'll get it done this week, I promise.
And I stamped mine in yesterday.
I saw
I
that.
think that was
Thank you.
30, I forget what it was.
So,
I emailed the, Brian's time.
If I know that people are,
okay,
looking to get going, like I do it right away.
okay.
Try to.
Like these guys, I'll wait up.
We have one application for next month, which is 9 Masconomo.
Over.
Oh, yeah.
Ron
Is it Joe Cunningham or is it?
Ron
Giovanni?
The chair,
Giorgio?
the former chair.
Ron
of the
DiGiolamo?
planning
Yeah.
board.
Oh. Yeah, I can never say his name.
Ron DiGiolamo?
No, Di Giacomo.
Di Giacomo, his house. And the house is being torn down and a new one is being built. And it is the wrecking crew. John Dunn.
No, it wasn't Di Giacomo, it was,
Is it the one that has the awnings on it right now, the old school?
It's the one that looks like a church.
Yeah,
that
yes,
one.
exactly. Yeah, it has the awnings on the outside that could, yeah, it looks like,
They're
Yeah.
gonna tear it down.
oh, that was an old church, wasn't it?
Yeah.
Yeah,
Yeah.
yeah.
Right on the elbow, the
Yeah.
curve there.
Yeah.
Yep, it is a
Yeah.
funny looking.
I know that thing's, I pass it every day.
I ain't
The
seen
market
it
for
in
long.
the listing agent
Girl that-
showed it to me. I went in it. It
I
was-
thought about going.
I saw some pictures when it was
It was
That
on.
was cold, it was
Yeah.
cold and dreary and.
it had a Raised area.
Yeah, I looked at the pictures when.
And I think they're gonna attach the garage.
Oh, cause I talked to
I
him.
think Lisa got married in that church.
No, it hasn't been a church for a long
There's
time.
the new church
Long time ago. Yeah.
talking.
There's another church on that street,
Yeah, around the corner.
the Saint Episcopal.
Oh my God, it's the
Maybe
cutest church. I love, yeah,
I should have bought it, made into a Greek church.
you should have.
yes.
You and Nick.
People wish to discuss.
You and Nick,
No,
Zacharias could all do.
Next.
You get all the Browns too.
Be in Florida, so if I need to, I can comment.
For you, Colleen, get out of
That
here.
plane
And
better leave
That's-
on Friday.
Absolutely.
Our next meeting is, 1, 2, 3.
Paneras, Zacharias, Paneras,
Is that what we want?
Reyes.
I'm gone the entire month.
Are we
of
talking
March,
Greek
so
names?
Oh, well, that's a tough
Everyone always
one.
thinks
I know.
my name's
Okay.
Georgia.
I've already missed one trip because of the snow, so hopefully this one.
Okay, we gotta convince Rob. I don't hear anything from Rob Scott.
So if I can always zoom in, if you need an extra.
Jean is back from his cruise.
But is that the only one that we
Yeah,
have?
he'll be back for next weekend.
And is it to give them the ability to tear it down or is it to put something new?
No, we don't,
We don't care. We don't care.
no, we don't rule on the tearing down. It may be both a variance and a special permit.
Okay.
I think the garage is in the setback. What is it, was a detached accessory structure, so we think we'd have to have a variance to attach the accessory structure to the primary structure.
Okay.
It's in the setbacks. And I asked him to. He doesn't have any plans on the existing structure.
Master Giacomo. That was his name.
Thank you, Jack.
Master Giacomo, something was an M there. It started with an M.
Giacomo's, yeah.
So, I asked him to at least give us what the existing height was. So I'm not expecting, usually they give us existing floor plans.
Yeah.
He doesn't have them. and I said,
Oh, he doesn't have that, okay.
Yeah.
I mean, that's step one. Yeah.
Yeah.
At least get the surveyors out there and give us something.
That's what I said.
Give us
We
the
need-
base.
We need a survey with a footprint. and
Exactly,
We
yeah.
need to understand what the existing height is. I think it's high, but I don't. But that's our only application.
Alright.
Good.
You gonna make that motion?
Motion to adjourn.
Do I have a second?
Second.
All in favor?
Yes.
Aye.
I've never done that before.